How much money did he take from somebody to issue this certificate? This is exactly what you want.
No, it's not about what
For
I want. That is what
multiplicity
is
of
contemplated in law.
For frustrating the orders passed by the court, to force litigants, compel litigants to file one after other writ petitions only to get one order complied.
Frustration of your lordship.
You give a completion certificate where the bill amount is mentioned. After 3 or 4 years or 5 years, the defect liability period is over. You say there are deficiencies and I won't pay you. Can you do this?
Wait for people to change.
This
They
is
wait
where
for officers
the problem.
to change. Malad,
Why are your officers not conscious?
These are not people who are not aware of the timeline. These are not people who are not aware of the law.
Your people are very much in tie-up with these unscrupulous people, if you they say.
But I appear on behalf of the petitioner. Lordships kindly see Lordships last order 13th February 2025.
Yes.
But here, Lordships directed the chairman to clarify the works as completed satisfactorily by the petitioner. The petitioners the tender were issued, petitioner participated in the tender, got the tender and he completed the works.
Yes.
These the payment was raised, it was no bill was sanctioned and released. Then
the chairman of the Srirampur municipality was directed to remain present. Is
he
it there?
Present, Malad. I am appearing for the contempt, Malad.
Now,
He is present, Malad. He is present personally.
This chairman issued 8 certificate for 8 works. He says in the certificate, if your lordships can come, page 34 onwards.
Mr. Lahiri is also there. You are also there.
Malad, with the leave of my learned senior friend, Malad, may I address your lordship?
I do not know. It's between the two of you.
I'll address your lordship.
All right.
We are both there, Malad. I'll
Page 34 onwards in my contempt application, I have annexed all the certificate issued by this chairman.
1 minute. 34?
34 of the contempt application.
Yes.
Lord, 34 onwards, Lord, I have annexed 8 certificate issued by this chairman, this person.
Right.
Lord, this has been again signed by the assistant sub-assistant engineer. He says in each and every work,
satisfactory completion of work. Now what has happened?
He has completed the above work satisfactorily.
Now what has happened?
Now, Lord, the bill was raised, Lord, if your lordships kindly come. Now, Lord, the bill was raised, Lord, if your lordships kindly come. Page before that, 33. 33, Lord, this says, last part 1 paragraph, therefore, this office has sanctioned a total amount of 28,85,630 out of 34,85,630. Lord, this Pradhan, this chairman, Lord, that bill where, Lord, this chairman personally says that all the works done satisfactorily. And Lord, the indication works, the tender notice number, work order, estimated amount and bill amount, all are written each and every certificate.
All right. Yes.
Yes, Malad, if your lordship, Malad, kindly comes, Malad, to your lordship's order, which is at page 20, kindly takes page 21.
Yes.
Second paragraph starting with accordingly.
Yes.
Accordingly, the writ petition is disposed of by directing the chairman to take into consideration and decide the prayer of the petitioner seeking disbursal of his dues. An opportunity of hearing shall be given to the petitioner for production of necessary documents in support of his claim. A decision shall be taken at the earliest but positively within 12 weeks from the date of communication of this order. If the municipality is of the opinion that the petitioner will be entitled to the dues as prayed for, then necessary steps shall be taken to disburse the same at the earliest but positively within 3 months from the date of passing of the final order. Therefore, a decision was required to be taken. Malad,
and payment to be made.
And payment to be made. Now, Malad, the decision which has been taken and first decision which was taken, interim decision which was taken, that a joint inspection is required. But accordingly, a joint inspection was done on 24th of August 2023. I go inspection of August. Malad, at the joint inspection, it was found that there is some deficiency of the work. Therefore, Malad, at that point of time, it was order was passed that in place of 34 lakhs odd, 28 lakhs odd will be paid to the petitioner. That is, Malad, admittedly in which is contrary to the completion certificate. But my lord, at the same time, these completion certificates were also part of the records in the writ petition. Your lordship has been pleased, after looking at these completion certificates, to give a direction upon the chairman, take a decision. The decision which has been taken is that there is some deficiency of work. My lord, the inspection report is also with me, my lord, where the deficiency has been noted. It's another thing that it has not been communicated to him. My lord, today an order has been passed on in September 2023. Now, my lord, that order is not under challenge anywhere. He is seeking to, my lord, challenge the order before lordship in the contempt proceedings. Now, my lord, in the contempt proceeding, my lord, your lordship is being invited to go behind the order today and to pass an order, my lord, which is today, my lord, in my humble submission, contrary to page 21. My lord, if my decision is wrong, he can always challenge that it's a subsequent cause of action.
Is your client not taking the court too lightly?
My lord, he's not.
He's not?
He's not, my lord. But
He has mentioned it to be done, though it means the work to be done satisfactorily in 2018. The work was completed in 2018.
yes.
In 23, you go there and for an inspection and find there are deficiencies. How can it be?
My lord, that is,
Had the person been different,
my lord,
it would have been otherwise. The person concerned is the same.
my lord, if your lordship kindly takes page 20 also.
20.
20. That is the first page of the order. First page of the order.
No,
But
why look into all these things?
that is the contemplation on in the order itself. That was the submission of the municipality, on the basis of which your lordship passed an order.
It is all
Kindly
right.
take the recording in your lordship's order, my lord.
No, it's all right. But the documents speak that the chairman was satisfied. Specific submission has been made in court that the chairman required he called for money to be paid. This the court will not permit.
My lord,
No matter how much you try to go otherwise,
my lord,
submission was that he has demanded money for
It is-
releasing payment.
it is rather other way around, my lord, where there is the deficiency of work, and now since the payment is being withheld, my lord, these submissions are being made, and the allegation made in the representation, when the specific submission of the municipality at page 20 recorded by your lordship is that the payment will be made after joint inspection.
Absolutely. How did this person issue the satisfactory certificate?
It was wrong.
What?
It was
It
wrong.
was wrong. What will be the penalty?
So it was- it
How,
was
how much
wrong.
money did he take from somebody to
No,
issue
it
this
is-
certificate?
my lord,
From either to give the
kindly, my lord,
certificate.
pardon me for saying this, but it's a wrong imputation upon my client, my lord.
It
Because, my
was,
lord,
listen,
it was
it is very
never-
clear. If the certificate is mentioned, if the certificate mentions satisfactory work done, either that was incorrect, or now if it says there were deficiency, that is incorrect. Either of the two, both cannot go together.
completion certificate was, my lord, these 8 works are there. 8 works are there. My lord, the deficiency has been found in 2 of the works.
Are the completion certificate given satisfactory completion
It's
certificate
wrong.
given?
It was wrongly given at that.
How was it given?
At that time, the record should have been properly checked.
Yes.
At the time.
This is the query of the court.
Yes.
How could it be done? And it was countersigned. Not only he,
If it,
countersigned by the sub-assistant
that
engineer.
same sub-assistant engineer, my lord, has made this inspection report saying that there is deficiency in the work.
How come this come? Where is the error?
Well, I am
It has to be seen.
error,
There
my lord.
is
I can
something
give by calculation, my lord. But your lordship will kindly, my lord, appreciate that the order passed, my lord, the completion certificates were before your lordship, my lord. My lord, if it was your lordship's intention that in terms of the completion certificate, since it's admitted fact, an admitted amount is to be paid, my lord, that could have been the order. But that was not your lordship's order. Your
and
lordship
is very conscious.
Yes, exactly, my lord. That is my submission, my lord. After hearing the municipality, your lordship decided that yes, maybe there is some merit in the submission of the municipality that a joint inspection should be held, and that order is passed in 5th of April 2023. But pursuant to what is contained in the order, a joint inspection is held and some deficiency is found.
Yes.
Now, my lord,
this
if it is wrong,
where the problem lies.
if it is wrong, my lord, their course of action is in a subsequent writ petition.
This
Today
is
they
what
are
you
trying
want.
to go beyond, my lord,
This
the
is
order passed.
exactly what you want.
But it's not about
For
what I want. That is what is
multiplicity of
contemplated in
proceedings,
law.
for frustrating the orders passed by the court, to force litigants, compel litigants to file one after other writ petitions only
My
to
lord,
get one order complied.
Frustration of your lordship's order will result, my lord, if we fail to decide the prayer of the petitioner seeking disbursal of his dues. An opportunity of hearing shall be given to the petitioner for production of necessary documents in support of his claim.
Lordship,
My
can
lord,
you come
this
page
is,
32?
if we had not done so, if we had not released, my lord, the amount which we have admitted, we have also disbursed that. we were in some financial crunch. We disbursed in two halves. One we paid one half, then we
Whatever,
paid one
you
half.
paid.
But my lord, we have paid the admitted part. So, my lord, it is not our intention, my lord, either to disobey or frustrate your lordship's order. But withholding 6 lakhs just to, my lord, be in contempt of your lordship's order, that is not our intention. That cannot be our intention.
It can be.
But it is not. But this imputations upon my client just because a completion certificate has been issued, and my lord, when he says after inspection with measurements and recordings in the inspection that there is some deficiency of the work, my lord, it is my humble submission. It was not your lordship's contemplation to pay the entire demanded amount which was demanded in the writ petition.
It is not the demanded amount. The figure was never mentioned in the order.
It was to be decided.
It was to be decided by you.
That
Then
is what I
you-
decided.
You give a completion certificate where the bill amount is mentioned. After 3 or 4 years or 5 years, the defect liability period is over. You say there are deficiencies and I won't pay you. Can you do this?
My lord, we have found out that there is a deficiency. My lord, this is public money which is to be paid to the petitioner.
Exactly.
My lord,
This is
if the
public
work is
money.
not there, we will be. My lord, if your
How
lordship,
can you give this completion
if your
certificate?
lordship says that to drop the contempt, this amount is to be paid, my lord, we will be ending up paying the contractor for a work which they have not done.
Right. How did you give this certificate?
It was wrongly given. It was wrongly given.
Now, when
the
you are
record-
caught on the wrong foot, you say
Well,
that
we
it
are-
was
we are
wrongly given.
absolutely not on the wrong foot because it was not your lordship's contemplation that the entire amount is to be paid. That was not your lordship's contemplation. Today, my lord, the scope of the contempt is being enlarged as if it's a fresh writ petition where they are challenging my reasoned order. Well, I asked
You
this
didn't
question.
order at all.
Yes, my lord, we have passed an order saying that this amount only 28 lakhs
This is a
is
report
being.
type. This is not a. This is not an order.
My lord, this is kindly see the my lord, the nomenclature may be different, my lord.
Oh,
Kindly
whatever.
see the texture of the order, my lord.
Assume also, right?
My lord, I asked this question to myself that why they have not challenged this order. If there is any difficulty, my lord, this is not a fresh order. My lord, these are
Exactly. This is what you want.
November 2023.
This is what you want.
My lord, it is not about, my lord, what I want, but it is what the law says that if an order has been substantially complied with, it is a fresh cause of action which they have to challenge in a separate proceeding. There is the contemplation of the law. My lord, it's not about me wanting something.
Lordship, kindly come page 32. This is 11th October 2023. The chairman issued a notice to my client saying,
And also kindly
Saying
notices page 42. After 2 months, he realizes this. After 2 months.
The petitioner was requested to visit the office on 17th October at 5 p.m. because a discussion is extremely required. After the inspection, this has been written, and work was completed 2018.
Yes.
They have written the
Or complete 2018. It is my mistake. I did not take the point of limitation, my lord, at that stage. It is my mistake.
They says that the reason of they says that the inspection shall be made, but that is not at all. Page the 31, I have written a letter that you have wrongly stated in your reason order that the inspection shall be made.
Inspection did not take place.
Take place.
Then
He says that when the reason order passed, the hearing was made, he never says the inspection shall be made. Never says. But he written in the order dated page 30, the 14th August 2023, he's written that inspection shall be held on 24th of August. Now, after getting this the copy, I said my client written a letter on 19th August that you have wrongly mentioned that your reason order that this joint inspection was decided during the hearing conducted such and such. Never say so. And after that, the 11th October asks the chamber of the chairman and saying something. Now this ultimately when my client is this is the output of this. Against each and every work indication, the tender number, work order, estimated amount, bill amount, and date of completion, and then last the written that satisfactory completed. If this satisfactory completed, how the question after 6 years or 7 years the quantum of the work, how it can be measured?
what was the defect liability period? Was there any defect liability period?
Yeah.
What was the defect liability period? What was the defect liability? Are you aware?
No, my lord, I am not aware.
Because the completion date is in August 2018.
Everything is in 2018.
Everything in
They came after 5
2018.
years. They came after 5 years.
You forced them to come. It is not that they came after 5 years out of choice.
Milord,
You will get work done, not pay the money, and then you say they
But
came
I-
after 3 years, 4 years, 5
Milord,
years.
at the cost of repetition, Milord, this may sound repetitive. I may have made this submission in some other matter also, Milord. Milord, the contractors are extremely aware that when they need to come approach the court, Milord, because these are running contractors, these are local contractors who these are not people who only got 8 work orders. Milord, these are agencies who have running work with the municipality, and Milord, that is why they choose not to come at an appropriate point of time. They know that there is some deficiency in the work. They wait for regimes to change. They wait for people to change.
This
They
is
wait
where
for
the
officers to
problem.
change. Milord,
Why
it is-
are your officers not conscious?
these are not people who are not aware of the timeline. These are not people who are not aware of the law.
Your people are very much in tie-up with these
But
unscrupulous
Might
people, if
be
you
in
they
some
say.
cases it is, Milord, might be in some cases your hunch is absolutely right, but not in this case. In this case, Milord, the
If everything
what
was so very proper,
what
then why was the payment not being
Milord,
paid?
Milord, if the petitioner submission is to be accepted today, Milord, at least in this case, I can say it will be making payment for a work which is not done.
What punitive steps will you take against the chairman and the executive engineer who had certified that
Milord,
the work was completed
Milord,
satisfactorily?
as far as the
I want to
chairman,
see
Milord,
that.
as far as chairman is concerned, he is
Chairman,
a
he cannot.
elected person, Milord. He
Cannot be
yes.
done. Executive engineer, let
Milord,
me
as
see.
far as executive engineer is concerned, Milord, if we'll
You
take
take steps. You are the municipality.
I am, yes.
You
yes,
take steps.
yes.
Bring before this court. On the next day, what steps have you taken?
And one of the after
Please
detection,
come.
not only one submission I am making, but the payment has been made. But the amount has been deducted from this amount. The TDS income tax amount not deposited. CGST some amount deposited.
I will pay penalty to the income tax
GST,
authorities.
some amount deposited. But the income tax cess not deposited by this office.
I will pay penalty. The other authorities are there for that.
Please come.